An accused cannot be kept in custody for indefinite period if a trial is not likely to be concluded within a reasonable time. Detention cannot be punitive or preventive. Mechanical reduction of sentence to the period already undergone cannot be appreciated. The court is duty-bound to award just sentence to a convict against whom charge is proved. Sentence has to be fair not only to the accused but also to the victim and the society. Non-disclosure of certain offences at the time of filing of a nomination paper creates an impediment in the free exercise of electoral right, and such non-disclosure amounts to undue influence. Second generation Christian converts can retain the benefits of the caste even after they reconvert to the original caste. When a tribunal refuses to initiate contempt proceedings, the aggrieved person has remedy only under Article 136 and not under Article 226 or 227 of the Constitution. A magistrate has discretion either to direct registration of a case under Section 156(3) or to conduct inquiry himself as the situation may warrant. This discretion is to be exercised by the magistrate in his wisdom and having regard to the nature of material available. Direction under Section 156(3) to register a criminal case and to investigate is to be exercised where the magistrate is satisfied that prima facie a cognizable offence has been committed. There cannot be a reduction of a sentence whenever an accused offers acceptable compensation for rehabilitation of a victim, regardless of the gravity of the crime under Section 304A IPC, though periods of limitation, being procedural law, are to be applied retrospectively. Yet, if a shorter period of limitation is provided by a later amendment to a statute, such period would render the vested right of action contained in the statute nugatory, as such right of action would now become time-barred under the amended provision. In cases of composite negligence, the claimant is entitled to sue both or any one of the joint tortfeasors and to recover the entire compensation, as liability of joint tortfeasors is joint and several. Photographs of only the Prime Minister, President and the Chief Justice of India may be used in advertisements released by central and state governments after obtaining prior permission. National Company Law Tribunal and National Company Law Appellate Tribunal are constitutional. The welfare of the child is of paramount consideration vis-a-vis the perceived rights of parents. If a single parent or unwed mother applies for the issuance of a birth certificate for a child born from her womb, the authorities concerned may only require her to furnish an affidavit to this effect and must issue a birth certificate unless there is a court direction to the contrary. It is the responsibility of the state to ensure that no citizen suffers any inconvenience or disadvantage merely because the parents fail or neglect to register the birth. Petroleum and Natural Gas Regulatory Board is not empowered to fix or regulate the maximum retail price at which gas is to be sold by entities like Indraprastha Gas Limited to its consumers. The Act does not confer any right on the board to fix the tariff of a consumer of natural gas, while state governments are not competent to impose taxes or levies on industrial alcohol. Fee charged for services rendered to prevent the diversion and conversion of industrial alcohol for human consumption is permissible and legal. Such a fee need not be charged strictly on quid pro quo basis, and it will pass legal muster so long as it is not excessive. A tax is levied as part of a common exaction, whereas a fee is payment towards services rendered. A sentence of death in a case of murder may be rare, but if the courts have, upon consideration of the facts and evidence, found that the same is the only sentence that can be awarded, it is difficult to revisit that question. In collateral proceedings, the provisions of section 364A, insofar as the same prescribes death or life imprisonment, is not unconstitutional, and the punishment prescribed for those committing any act contrary to section 364A cannot be dubbed as so outrageously disproportionate to the nature of the offence as to call for the same to be declared as being declared unconstitutional. The inherent power of a High Court under section 482 Criminal Procedure Code should be sparingly used. The High Court should exercise this power only when the court comes to the conclusion that there would be manifest injustice or there would be abuse of the process of the court if such power is not exercised. While exercising its inherent powers in economic offences, it must keep in mind that the society at large has been defrauded. When government transfers land or any interest therein to any person, such a transfer is not governed by the Transfer of Property Act 1882. The rights and obligations flowing from the transfer of either a piece of land or an interest therein by the government cannot be determined on the basis of the rights and obligations specified under the Transfer of Property Act 1882. They are to be ascertained only from the tenor of the document made by the government evidencing such a transfer. The Supreme Court has struck down the 99th Amendment to the Constitution as unconstitutional. The 99th Amendment pertains to setting up of a National Judicial Appointments Commission for appointment of judges to the Supreme Court and High Court. An environment compensation charge has been imposed on all light and heavy duty commercial vehicles entering Delhi. However, the above charge shall not be imposed on passenger vehicles and ambulances and on vehicles carrying essential commodities. The amount so collected to be exclusively used for augmenting public transport and improving roads, particularly for most vulnerable users, that is, cyclists and pedestrians in Delhi. While availing benefits under the Aadhaar card scheme, the following schemes are also to be included: the Mahatma Gandhi National Rural Employment Guarantee Scheme, National Social Assistance Program, Old Age Pensions, Widow Pensions, Disability Pensions, Prime Minister's Jan Dhan Yojana, and Employees Provident Fund Organization. However, the Aadhaar card scheme is purely voluntary and it cannot be made mandatory till the matter is finally decided. There is a distinction between a decree for divorce and a decree of judicial separation. In the former, there is a severance of status and the parties do not remain as husband and wife, whereas in the latter, the relationship between husband and wife continues and the legal relationship continues as it has not been snapped. Therefore, the claim preferred under Section 12 of the Protection of Women from Domestic Violence Act 2005 is valid as she has not ceased to be an aggrieved person under Section 2A of the Act. No person can claim the name of a holy or religious book as a trademark for his goods or services marketed by him. The registration of the word Ramayana as a trademark being the name of a holy book of Hindus, is prohibited under Section 9(2) of the Trademarks Act. The Supreme Court has directed all the states and union territories to consider the plight of acid attack victims and take appropriate steps with regard to inclusion of their names under the disability list. A constitution bench of the Supreme Court has held that in respect of cases where the sentence is imposed by the criminal court under any law which falls within the proviso to Article 73(1)(a) of the Constitution, then the appropriate government would be the central government for exercising its power of remission, suspension as well as commutation as provided under Section 432 and 433 of the Criminal Procedure Code. In all other cases, if the sentence order is passed by the court within the territorial jurisdiction of the concerned state, then the concerned state government would be the appropriate government. Also, where the law came to be enacted by the Union in exercise of its powers under Articles 248, 249, 250, 251 and 252 of the Constitution, though the legislative power of the states would remain, yet the combined effect of these articles read along with Article 73(1)(a) of the Constitution will give primacy to the Union government in the event of any laws passed by the centre prescribing the executive power to vest with it to the exclusion of the executive power of the state, then such power will remain with the centre.